Is Lindsey engaged in foreign policy negotiation in violation of the Logan Act? Certainly, it's become a common question on social media. This X account writes, unless POTUS gave Lindsey Graham permission to negotiate with Ukraine, he is violating the Logan Act, which is 18 U.S.C. 953. We'll take a look at that in a moment. He could face 3 years in prison if convicted. We'll take a look at the actual statute in a moment. Here's another post on this question. The Logan Act prohibits unauthorized negotiations with a foreign government, and Lindsey Graham and Richard Blumenthal are in clear violation of it. Do you want the FBI to arrest Graham and Blumenthal the minute they step back on American soil? Here's another one. Mr. Lindsey Graham joins a long list of Democrats. I don't believe he's a Democrat. I believe he's a Republican, but it doesn't really matter, who have violated the Logan Act but are never charged. If nothing else comes of this, I hope President Trump finally sees that the snake he calls a friend is a dirty, backstabbing Democrat. Another one. It's no accident Zelensky sabotaged the peace talks immediately after meeting with Lindsey. If the Logan Act means anything, Graham would be prosecuted. Narrator voice. The Logan Act does not, in fact, mean anything. The same folks accusing Lindsey Graham of violating the Logan Act for visiting Ukraine had no problem with former President Trump hosting Netanyahu at Mar-a-Lago or Trump's multiple calls with Trump prior to his election. Now let's take a look at what the Logan Act actually says.
Did you know that in all 50 states, self-defense law, not gun law, but self-defense law, uses a simple 5-element test to see if your use of defensive force was legally justified? And that same test applies no matter what state you're in or what tool you use to defend yourself. If you're missing even one of those required elements, however, you've made yourself an easy conviction for an aggressive prosecutor. My name is Attorney Andrew Branca, and I've worked more than 30 years as a self-defense attorney. Every state has seemingly endless, complex pages of laws regarding self-defense, so complex that many top criminal defense attorneys rely on my expert analysis to help win self-defense cases for their clients. If the legal code is that complex for lawyers, how can a citizen gun owner expect to know or even follow the law, especially when a life or death situation has triggered a massive adrenaline-fueled mandate to make that fight or flight decision right now? It seems daunting. Yet I created a simple but powerful framework that has allowed me to serve the legal community and countless American gun owners to simplify this legal complexity into just 5 elements of self-defense law. And you can learn my 5-element legal algorithm I use to consult on and win with the top criminal defense attorneys all over the country to protect law-abiding gun-owning citizens from making innocent legal missteps that land them in prison. Now, with a simple read or listen, you can install my 5-point legal framework so it acts as a sort of muscle memory defense to protect you from losing your rights when you choose to defend innocent human life. Click below to get the latest edition of my book, The Law of Self-Defense Principles, for free. I ask only that you help cover the shipping and handling cost to get the book to you.
So this is the Logan Act. It was initially made law in 1798 or 1799, so not long after the Revolutionary War. It's since been codified into the U.S. Code as 18 U.S.C. 953, private correspondence with foreign governments. It reads, any citizen of the United States, wherever he may be, who, without the authority of the United States, directly or indirectly commences or carries on any correspondence or intercourse with any foreign government or any officer or agent thereof with intent to influence the measures or conduct of any foreign government or any officer or agent thereof in relation to any disputes or controversies with the United States, or to defeat the measures of the United States, like ceasefire negotiations being carried out by President Trump and Secretary of State Marco Rubio, shall be fined under this title or imprisoned not more than 3 years or both. And the second paragraph just says you'd still have a right to seek compensation from a grievance against the foreign government. Here's the big problem with the Logan Act. First of all, it's often very difficult to tell if someone is engaged in this conduct. Simply having a conversation doesn't qualify. So this account that said, hey, no one complained when Trump did it. Well, the question becomes, when Trump did what? When Trump did what? Was he negotiating with Netanyahu on foreign policy during the Biden administration? Or with Putin? Or was it just a conversation among global leaders? We can speculate, but we don't know. And the other problem with the Logan Act, the big one, is that no one ever has been charged under the Logan Act. Not in the 226, 227 years it's been on the books. Not a single person has ever been charged, much less convicted or imprisoned over the Logan Act. So is it law? I mean, is any statute law until it's actually applied to real people in real cases, interpreted and applied by the courts? Do we know it's valid if it's never had any subjection to court review? We just don't. And I think that's one of the many reasons it's never actually applied. So anyone hoping that Lindsey Graham is going to suffer any Logan Act consequences for his many visits to Ukraine, I'm afraid you're going to be disappointed. That's simply not going to happen.
Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.